In the state of Texas, we have what's called a homestead. The homestead is a provision that has been set out in the Texas Constitution. And what it does is it creates certain exemptions that preclude the seizure of or forced sale of property. Since the homestead interest is considered an estate in land, any legal process concerning the homestead involves the title of real estate. What the homestead law does is that it protects property that has been designated as a homestead from being taken or forced sale to satisfy a loan. Now, there are certain exceptions to that. For instance, a mortgage holder, or in other words, say a lender who has a first lien on that property and provided what's called purchase money, in other words, the funds when the property was purchased are exempt from the Homestead Act and they can exercise their security interest. A taxing authority can exercise an interest in the property, and a holder of a note that's created for a home improvement loan. Whenever we created the home improvement loan, the provisions within the Constitution, it allowed a lender to take a security interest in, say, a house that was designated as a homestead, but yet that money is not being provided for purchase money, but rather for home improvement. And so the Homestead Act is there to really protect against someone taking and giving their second or third lien on property that they could have designated as a homestead, and then the creditor being able to exercise those liens. The Homestead Act is also useful in the ad valorem tax purposes for the protection from creditors. You can get a certain exemption for a certain amount of the value of property if it is considered your homestead, so it's not taxed completely. The types of homesteads that we have are an urban homestead and a rural homestead. The typical urban homestead is a residence. You can have up to 10 acres that would be considered your homestead. It doesn't have to be in one contiguous block. It can be in different lots. It doesn't have to be next to each other. Most of the urban homesteads are residential homesteads. People who have purchased a house will declare that to be their homestead. The two types of urban homesteads are residential and business. The residential homestead is a property which a party claims as his residence and can include contiguous or non-contiguous lots. It's also possible to claim a business or commercial property as a homestead. Now, the rural homestead is set out in the Constitution as being a family can claim 200 acres of land, or a single person or single adult can claim 100 acres of land. So, give you an example. Let's say you have a half a section, which is 320 acres. You can claim or designate a certain 200 acres of that 320 as a homestead. Now, whenever you purchase that farm or that land, the lender who loaned you the money to purchase that land would have a first lien in all 320 acres. Now, if you gave that property as security for another loan that was not for purchase money, out of that 320 acres, 200 would be protected from that second lien holder. So we need to learn, keep in mind that you can have a first lien holder that is purchase money, which can exercise a security interest. A second lien holder that is not purchase money could not exercise that security interest. We could ask the question of why would a lender take a second lien on a homestead if they cannot exercise that security interest? Sometimes you have a case where you may have a carryover note or carryover debt, and the bank needs to have a security to back up that carryover debt, and they will be willing to take a second lien on property in order to secure that. They may take a second lien on property that is a homestead, even though they cannot directly go in and exercise that security interest if need be. The reason they might take that is because that once that second lien is filed, the owner of the property cannot sell the property unless that second lien is taken off. In other words, it clouds the title. In other words, there's no way they can give a warranty deed to someone else and sell that property until that second lien has been discharged, or the buyer of the property is willing to discharge that second lien. So a lender might take a second lien on property knowing that they cannot directly exercise that security interest, but they are in effect making it to where the owner of that property cannot dispose of that property unless they clear that second lien.